This.
The people's champion. Our mission is love. Our vision is love. Jamaicans for justice. The people's champion. Justice, justice for all. Justice under the law. Justice, Jamaica demand. Right to life, right to liberty. Justice, justice for all. Justice under the law. Justice, the people demand. Right to life and security. Oh, what a joy.
Welcome to Let's Start Justice. It is Tuesday, September 16. It's 1 p.m. And you are being joined by Jade Williams from Jamaicans for Justice.
And I'm Mikkel Jackson, Executive Director of JFJ.
All right, so this week we have an engaging discussion, I think. We're going to be talking a little bit about our bail legislation that came in place last year. I'm not going to give you all the details yet. But yeah, so we'll be talking about that, and we'll be joined by attorney at law Matthew Hyatt, who is instructed by Knight Junior Samuels.
All right, so the week that was, last week you were graced with our community engagement officer.
Yes.
And I enjoyed the show. I was watching it from where I was, 12 hours ahead.
Right.
Not being able to sleep.
You're
but
watching it
was
in the
a good
future.
show, I tell you. All right. So last week, the Jamaica Gleaner published 2 articles that are of concern. Now, the Jamaica Gleaner indicated that attorney at law Andre Earl, King's Counsel, had sought to have an access to information request appealed. But upon trying to make that appeal to the appeal tribunal, apparently there is no appeal tribunal in place, which is very concerning. And with that in mind, I want the listeners to appreciate some areas now. It is a constitutional right that we all have in Jamaica to seek and receive information. We have that right. And that right is so legislated in the Access to Information Act of 2002. The Access to Information Act of 2002 indicates that as citizens, media practitioners, we can write to any ministry, department, and agency and seek information on how the business of the country is operating. There are certain exceptions to this. For example, if there is information that may detail the personal information of a civil servant, for example, that would be exempted. So there are some parameters. But if you want to know how a meeting was happening at the National Housing Trust, for example, then you can write to the National Housing Trust that would be equipped with an ATI officer and get that information. Now, it's a couple things that came out in that article and the news cycle. We have found a disturbing trend emerging where the Data Protection Act is being used as a legislative provision to deny information that is of public interest from being shared. That is very concerning because the provisions of the Data Protection Act, which is ultimately to protect your privacy rights, for example, your health status, from being made public, being disclosed in an unlawful manner. Right? But back to the Gleaner article. The legislation also indicates that an ATI appeal tribunal is to be there for 5 years. The 5 individuals on that appeal tribunal is to be so appointed by the Governor General upon the advice of the Prime Minister after consultation with the leader of the opposition. Based on that article, months have passed and there is no appeal tribunal. So in other words, after you have made a request for information, say it was denied or not fulsomely provided, and you want to appeal, what you have happening now is that effectively your right to appeal has been denied. That is very problematic. And you have the highest offices of our land, which is the office of the Governor General and the office of the Prime Minister, not adhering to the law. Because not naming a new tribunal means that you're not adhering to the statutory provisions as is outlined in the Access to Information Act. And we're saying in an era of transparency that ought not to be. So we're calling on the office of the Governor General, the office of the Prime Minister, to name that appeal tribunal as a matter of urgency. And I would hope the media practitioners, including Nationwide News Network, where the article emerged last week to say that the Data Protection Act was used as a reason for information of national interest relating to the status of the Office of the Director of Public Prosecution not being provided for. That's unfortunate. It's not in keeping with transparency. And in an age of information to which we have a constitutional right that ought not to be accepted, neither by Nationwide, journalists, or citizens of Jamaica. Those who make the laws must adhere to them, even more so than us as citizens. And I think we ought to do better, and I think we ought to again collectively call on the Governor General's office, the Prime Minister, but even the leader of the opposition. If it is that you are expected to be consulted on something and you have not been consulted, you can't wait until after it becomes public. Then you're joining in the chorus. Who is proactively leading on these matters of national interest, ensuring that these appeal tribunal, the Public Services Commission and so on, they have been established. All of them have dropped the ball, quite frankly.
You know, I think another point of importance on this matter related to access to information is the review of the legislation, which would have been overdue.
Every Minister of Information, including the past Minister Nestor Morgan, has promised a review. To date, nothing.
And especially in the context of new legislation that affects the way we can access information, like the Data Protection Act, it's never been more important for us to have a review of this access to information.
You know how your money being spent, eh? Public, let us wake up together, man. Let us wake up. Too much money is spent and we don't know how the business of the country operate because they hear that you can't give information because of Data Protection Act. When that legislation have its own provisions. And what is even worse, when the Information Commissioner of the Data Protection Act would have come out and say, I don't understand how you can't give information because of those parameters. So what should be protecting our right to privacy is being used as a means of circumventing another right that we have.
Yes.
Come on, people. Anyway, that was it for the week. No, I was very upset when I saw those articles, Jade.
I know. All right. So we're going to be talking a little bit about bail today. And in line with that, we do have our right of the day and our trivia question. So our right of the day today comes from section 14 of the Constitution, and it speaks to your right to freedom of the person. And under the right to freedom of the person is a specific right to bail. So for those of you who are not aware, it is not just that our bail provisions are there to protect our right to freedom of the person. They are specifically there to protect a specific right to bail. And that means if you are awaiting trial or you are detained in custody, you should be entitled to bail on reasonable conditions unless there is sufficient cause to show that you need to be kept in custody. Now, our trivia question for today speaks to the review of the Bail Act that happened last year, 2 years ago. So who was the chairman of the committee that reviewed the Bail Act? So it was reviewed by a Joint Select Committee of Parliament, and we'd like to know from you who chaired that committee. So if you'd like to respond, you can respond via WhatsApp to 2397583, or you can respond in the Nationwide chat. If you do respond in the Nationwide chat, please send that WhatsApp to 2397583. You can also respond on our Instagram pages.
All right, so we're discussing Well, ultimately, it's the right to bail, but it's
Yes.
via the Bail Act. And there are some provisions in the Bail Act, pre-charge bail and pre-charge detention. So we just wanted to do our duty here at JFJ in ensuring that the public is aware of the provisions in the newly passed Bail Act. So for those who may, I almost gave away your answer. So last year, a particular minister chaired the Joint Select Committee of Parliament, from 2022, and following several meetings that JFJ and others had made presentation, you saw a revised Bail Act of 2023 that completely repealed and replaced the Bail Act of 2000.
Yes, 2000.
Right? And the Bail Act was enacted on November 15, 2023. And there are some provisions in there that speaks to the deprivation of certain liberties that we may have as citizens, but we're going to be talking about that in detail shortly.
Right. So, we had made some objections to some provisions that were changed. So we saw, for example, the entitlement to bail was reinserted. That was originally removed in the draft. We also saw the police were given extensive powers in the original draft to give bail in some serious offenses. But those were revised in what became the final
And
Bail
I liked
Act
how
that
you
was
said
passed.
revised because we're going to make some
Well,
visit
anyone could go back and look at that
of the
joint select
schedule.
committee
Yeah.
session for the explanation on that. But yes, so we made those recommendations. We're glad to see that those were taken, but of course there were recommendations that weren't taken, particularly those relating to pre-charge detention.
It was amended a bit, though, but we're going to be talking through those with
Yes.
Matthew Hyatt, attorney at law, right away. Is Mr. Hyatt online? Not yet.
Okay.
But, Jade, if you recall, for example, initially how the legislation was drafted, it stated, for example, that the police had the power now to put you on bail conditions for certain, well, let me not say certain offenses, for a particular period of time. And if they want to extend those bail provisions or conditions, they would have to seek judicial intervention. But
Yes.
there was a little bit of a loophole because if I don't put you on bail conditions, it means that you'll be
Detained.
detained.
Yes.
But the legislation now has been quite revised to indicate that the detention period for up to a year for somebody not yet charged is up to the judge.
Right.
Yeah.
And while we welcome not the extensive period that was in the original draft, what is of concern is that the judge does not have any limitation as to what that period could look like.
I think it was amended, though, to definitely say up to a year. But we will double check.
All right.
Mr. Hyatt is on with us. Mr. Hyatt, attorney at law.
Good morning or afternoon.
You're a few hours behind. Good afternoon. Thank you so much. Well, let us just start with your initial, what you would call it now, response to the revised Bail Act, and just your initial thoughts around it, and then we'll start getting to some specifics.
Yes, well, I have seen the revised act. There are certainly some concerning portions of the act that many persons have raised issues with. One being particularly the pre-charge, the detention aspect of things in terms of persons not yet being charged and they are detained. That's definitely one of the provisions, a new provision that has come in place that many persons are concerned with. Defense lawyers and the Jamaican citizens also should be concerned about that aspect. And there is an aspect in the Bail Act which also says that where it is that persons are charged for murder and there is no evidence or self-defense does not arise on the prosecution's case, then bail may not be considered in those circumstances. Or, for example, if it is that the offense of murder is committed within a zone of special operations, then bail may not be considered. Those aspects of the Bail Act is very concerning to a lot of persons. And in my view, those portions of the Bail Act is unconstitutional, not yet tested by the courts, but certainly very concerning to a lot of persons.
All right, so we're going to probe that a little bit
Yeah.
after the break. Just stay with us. We'll take in the break now.
Live exquisite this year with new arrival black and chrome fixtures for your home at Unique Living. Select from a wide variety of rain shower systems, fabulous faucets, and stylish sinks to suit your kitchen and bathrooms. Get uncompromised quality and style unique to you. Shop everything new at Unique Living, Jamaica's leading shower and faucets provider. Visit shop number 630 Dunrobin Avenue, Kingston 10, or call 876-755-3661 to 2.
If it's important to you,
it's important to us.
let Nationwide 90 FM be your first choice for your live broadcast.
We'll drive traffic to your company, increase your publicity, and work with your budget.
Reach your target audience with high-quality audio both on air and online.
Nationwide 90 FM should be the driving force to execute your live broadcasts.
Contact our sales team today at 630-1210 or 630-1216.
Nationwide 90 FM live broadcasts covering your events and reaching your target audience.
Welcome back to Let's Talk Justice. We are joined by Matthew Hyatt, attorney at law, and we're discussing the provisions in our new bail legislation. Matthew, before we get too deep into the problems, or as a matter of fact, into the concerns that you've raised, I wanted you to just clarify for those listening,
Yes.
pre-charge bail versus post-charge bail versus post-conviction bail, because I realize we have three of them in the legislation.
Yes, we do. Or what most persons are used to is post-charge bail. Yes, and that is what applied before this new Bail Act. Now, the new Bail Act has what we call the pre-charge bail, where it is that a Jamaican citizen can be arrested or detained and without charge, and can be held for up to 48 hours before the question of bail is considered. There is also where it is that the police officers may need to do an ID parade, for example, or to get additional information in regards to the investigation. Then in those circumstances, the officers can have up to another 120 hours where the individual is so detained. And that is where we're talking about the pre-charge now. So you are detained without charge, and the question of bail at that stage can be considered. To my mind, it is inconceivable that something like that can happen. And while I understand that, the officers may need more time to carry out their investigations, but to have somebody detained without even being charged, the presumption of innocence, even at that stage, is an affront. To have somebody detained in the conditions of our lockups that we have it as, it is inconceivable.
Yeah, and I think the challenge I'm having, even with the ID parade provision, is that if it is that the police does not, find it sufficient, for lack of a better word, to put someone on bail conditions, and you need to bring that person before the courts within the 48 period, to now have a loophole that says if there's an ID parade in place, then you can have that person for 120 hours, which is really 5 days. I think those things are quite problematic when you look, as you say, on people's rights and so on. And just for the public to perhaps appreciate what we're saying, Mr. Hyatt, these are individuals who are not yet charged with a crime. So in other words, the
Yes.
police, they don't have enough evidence to charge you.
And this is also relying upon a perfect system. When we talk about bail is to be considered within 48 hours, before this act, it was within 24 hours.
Yes.
And now we're talking about the wheels of the administration turning perfectly for this to be complied with. There are times when we hear that officers are on vacation and the investigating officer is not here or the file is not yet completed. And so persons are in custody for 2-3 weeks before bail is
Yes.
considered.
And it's
And so-
almost like you're rewarding the state for its own inefficiency. That is a challenge we're having as well. Because at what point do you get your house in order before you decide to deprive someone of their liberty?
And that is so true. And you know, while I understand that the new Bail Act came in to deal with the high level of crime, but there is also a perception and a false perception of that it is the individuals who are on bail that is committing more of these crimes, and so persons have an idea that is being planted by some key persons within the state that once you're on bail, it is a big offense, it is a sin, and so once you're charged or once you're detained or arrested, you are this criminal that should be locked up.
You know, one of the challenges, because we made submissions on the Bail Act when the first draft came out. And one of the
Yes.
challenges that we had was that persons are expected to essentially submit to their right being restricted on no real reasoning. Because if there was real reasoning, you would be able to prefer charges.
Well, the Act clearly says, I think they use the word intelligence under Section 5.
You know, another challenge that I had with the legislation was even that, objects and reasoning, because bail, the purpose of bail is not to manage criminal activity. The purpose of bail is to manage the right to freedom of the person and to ensure that that right is not unfairly infringed upon. So to then justify changes to the bail legislation on the basis of fighting crime, again, presenting no statistics to show that, as Mr. Hyatt would have pointed to, that the persons who are on bail are those persons who are regularly committing a high level of crime. We weren't able to see that even in the Joint Select Committee. So it really comes down to, is this the reasoning that we should have used to manage or to change provisions in our bail legislation?
Yeah, you know, just to add that prior to the Bail Act 2023, I personally did not see a flaw in the last Bail Act because ultimately the judges are there as the tribunal of law, and they sit and they hear the prosecution's version and they hear the defense's version, and the same guidelines, almost the same guidelines, what a judge can use to consider whether to grant bail or not, is also considered at a point. And the judge's discretion is always there.
Yes.
So when we make these type of amendments, sometimes I have to wonder if there is some political motive involved to say, hey, see, we are doing something and we're making all of these legislative changes. But at times it is to the own citizens' detriment, because now a person who is absolutely innocent has to now wait another, beyond 24 hours, it has now gone to 48 hours before bail can be considered. And it is absolutely wrong.
And, you know, just for the public Just to quickly outline this, Mr. Hyatt, for the public to understand fulsomely what we're collectively articulating here. If you are suspected of a crime, the police can arrest you, and during that period, you are detained during the hours that we're mentioning. However, if the police believes that you can be placed on bail, it means that you're released, but there are some conditions that you must comply with. For example, you may be asked to report to a police station on a particular day and so on. Remember, people are working, You're not yet charged with anything. You're merely suspected, but you're asked to comply with certain bail conditions, right? If it is that there is sufficient intelligence, not evidence now to sustain a charge, but sufficient intelligence, what can happen is that you can be detained for a period of up to 12 months. That is within the jurisdiction of the court. But even that, Mr. Hyatt, I find problematic, and the reason being, for me, it's reminiscent of the 1974 Gun Court Act. Because while, and by the way, the earlier draft of that bill that we had flagged, where I can say with some confidence, and I use the word some confidence reluctantly, based on a particular section that says that after 6 months, you must be released unconditionally. The earlier version of the bill did not have such provision.
Yes.
Which meant that there was a loophole where you could have been indefinitely detained.
Yes.
For someone who has not yet been charged.
Yes. And it also defeats the purpose of the habeas corpus application now, because where it is that
and just explain what that is for the listeners, please.
Yes. So it is an application where it is that you are arrested and detained and you have not yet been charged for some period, then an application can be made for you to be released by a particular time. And well, I must confess, I still make those applications even now, but it really defeats the purpose of that now, because you can now be arrested and detained. And I am not sure if the pre-charge bail aspect is being used by the officers at this time, even with this new act. I am not sure if they have considered it.
Well,
I have yet to see it come into play where the officer says, "Okay, I'm holding on to your client, but I'm going to give him bail." I haven't seen that as yet.
To be fair, in the engagements that we've had with the JCF over this year so far, we've asked them about
select divisions. Let us
select divisions. Yeah. Yes, we've asked about their engagement with the legislation, and we found the sentiment is overwhelmingly negative towards the use of pre-charge. There have been maybe a division or two that would say, we need extra time to be able to find the evidence, and if you don't have these people detained, then they would prevent your ability from getting same. But then I ask, what about those extraordinary powers that you'd have under the Constabulary Force Act? Are those of no use to you in terms of how you would be able to manage an area, for example, or get evidence from citizens in that area? When I challenged it in that way, they were like, okay, I guess we kind of see where you're coming from with that. So I'm not sure that we exactly empowered them in the way that I think Parliament was hoping the provision would have.
Well,
yes.
Yeah. I just think, quite frankly, it prevents certain challenges from facing any government of the day.
Yeah.
I think that's perhaps what is trying to be mitigated here, if you look at some of the readings of some of these judgments. But Mr. Hyatt, if you could just stay with us for a few more minutes. When we come back, I just wanted to look at what happens in the UK, that I think is perhaps the only other jurisdiction that we could readily find that have some elements of this, and we touch on the other aspects of post-charge and post-conviction.
Yes, man, no problem.
At the Jamaica Customs Agency, we care for our employees, customers, stakeholders, citizens, and our country. Customs cares. The temperature by the Jamaica Customs Agency is
34 degrees Celsius in Kingston and 32 out west in Montego Bay.
On Thursday, September 19, 2024, tune in to Cliff Hughes Online from 10 a.m. to 12 noon as we live stream a panel discussion on generative AI, impact on misinformation and disinformation, hosted by the Broadcasting Commission of Jamaica in partnership with UNESCO Cluster Office for the Caribbean and the Jamaica National Commission for UNESCO. This event is being held within the framework of the 5th Global Annual Artificial Intelligence for Information Accessibility AI for IA Conference and seeks to raise awareness about the importance of inclusive access, ethical usage and governance of new and emerging AI systems. It will feature a keynote by Christopher Charles, Professor of Political and Social Psychology in the Department of Government UWI Mona, the launch of the Caribbean AI Roadmap, and a lively panel discussion. Thursday, September 19, Cliff Hughes Online from 10 a.m. to 12 noon. The discussion is Generative AI, Impact on Misinformation and Disinformation. All this and more only on Nationwide 90 FM, the new revolution in media. This broadcast is brought to you by the Broadcasting Commission of Jamaica.
On Thursday, September 19, from 10 a.m. to 12 p.m., Cliff Hughes Online will be hosting a special live stream panel discussion on generative AI, the impacts on misinformation and disinformation. As a result, regular programming will be interrupted to accommodate this important event. Please note that the Consumer Hour will not be aired and Cliff Hughes Online will begin at 9 a.m. with Cliff Says before the panel discussion starts. Nationwide 90 FM apologizes for any inconvenience this may cause and encourages you to stay tuned for what promises to be a highly informative discussion. Thank you for your understanding.
Welcome back to Let's Talk Justice. Before we took the break, I just wanted to bring into context the United Kingdom's similar provision, wherein if it is that you're placed on pre-charge bail, there is a maximum of 28 days within which you can be placed on such bail conditions and I think detained, if memory serves me correct. Whereas in the Jamaican Bail Act, as I stated earlier, it goes up for the possibility of a year. And that is the challenge that we're having, is that those who can place you on bail conditions for even the extended period of up to 6 months, it's within the remit of police officers, starting with constables. I believe, Jade, you can correct me if I'm wrong, Mr. Hyatt.
Yeah.
Yes.
As long as you're not the investigating officer.
Right.
And the other persons that fit within the category of deciding officials would be justices of the peace. So in other words, police officers and JPs, they have the power to place you on bail conditions, pre-charge bail, not yet charged with any offense, for up to 6 months. And the judicial review involvement comes if they want to extend that period beyond the 6 months. No, you.
That type of inconvenience now for a Jamaican citizen, you are on bail. But one of the conditions is that you have to report to the police station twice per week. You may have a curfew. And one of the things that I have thought of, the justice of the peace and the constables, will they have the proper training to look at a particular case and to say, okay, we don't need to have this person reporting 3 days per week, or we may not need to impose a curfew. And so this type of inconvenience is also something that we have to consider. Do these persons have the proper training? We're not talking about persons who are judges now and are in the legal system and would have a certain level of legal training to be able to address their judicial minds to a particular situation.
Yes.
What if a police officer on his own bias then, right? You know, determining that we're going to impose very draconian measures. That is something that would cause a problem, in my view.
And another thing, Mr. Hyde, if you could walk us through the offenses before in the previous Bail Act that the police would have some, what you would call it, jurisdiction over, versus what we're seeing in this new Bail Act. Could you outline the differences there for us, based on your experiences?
Well, in the past, the police could offer station bail for certain offenses, for example. So, indecent assault, maybe petty theft, larceny, crimes of that nature. Certainly, when it goes higher to offenses such as rape and murder, robbery with aggravation, then the police would not have any jurisdiction in that regard. That those offenses now would be left for a judge to then decide whether or not bail is to be considered. And so those are some of the things when we talk about the officers and the JPs needing proper training to now look at all of these offenses. That is certainly something that would have to happen at this point in time.
But you see, within the new Bail Act, Mr. Hyde, thanks for that. While murder still falls within the remit of the courts, when you look at the schedule of the offenses that the police and the JPs can offer or give the bail conditions for and so on, it now includes, I believe, firearm offenses, anti-gang legislative provisions. So the sentences for those offenses are quite high, even if you look at the principle of the mandatory minimum being 15 years. So and the reality is that my question is, if murder is one of the offenses, but firearm was used, whose jurisdiction would that come in? Would the offense of murder automatically mean that it's the judge and not the police? Even though it's perhaps gang-related and firearm, I'm not sure. I've never thought about it, but as we were talking, I said, let me ask.
I mean, that's a very good question there. And I think those offenses should be left for the judges to decide.
Yes, given the period within which, you can possibly detain, somebody's liberties being deprived based on the sentences.
Yes.
Yeah.
Yes.
All right. Let us shift focus, Mr. Hyatt, to post-charge. What does that mean? Well, I know you gave the definition before, but for those who are just joining, what does post-charge bail involve and the challenges you're seeing there?
All right. So you are now charged for an offense. The police have possibly done a question and answer ID parade, and they say that you are charged now for murder. In those circumstances, you will be required to go before the judge to determine the issue of bail. And I noticed that there is a practice in the gun court, for example, where the judge will first ask for the criminal records or the antecedents to see whether or not the person has any previous convictions. I can understand the helpful nature of it, especially to the judge, because to identify and to know whether or not a person has a previous conviction is necessary. But it still goes against the fact that bail should be considered forthwith. And sometimes getting that information takes quite some
Yes.
time.
Mm-hmm.
But other than that, there are several other factors that the deciding official must take into account in determining whether or not a person will be granted bail. The nature and seriousness of the offense is one. The need for preserving public order and the likelihood of whether or not that person will commit that type of offense if granted bail. The prevalence of the offenses in Jamaica, we have a high crime rate, especially ones involving guns. And so the judge will look at that as well. The antecedents, as I said before, defendant's character. Do you work? Do you have a fixed place of abode? Are you involved in any gang activities? Are you known to be a don, for example, in a particular community? And speaking of that, I noticed that sometimes there is a practice by some police officers, especially when the judge is on the side of granting bail. They may not have enough information, but they may whisper to the prosecutor, and the prosecutor will then say, "Oh, John Brown, he's involved in the John Brown gang." And that information alone sometimes will cause the judge to say, "No bail." And it is interesting because hearsay can be used at the bail stage. And so while the judge may not have any concrete evidence that a particular individual is in a gang, sometimes the mere fact that it is said by the police, the judge may want to think twice whether bail should be granted or not. So there are many issues that the judge has to take into consideration. And I dare say that our judges are brilliant. Our judges take the time to look at all the factors necessary before a person who is charged for a serious crime like murder or having a firearm go back onto the streets. So I don't want it to be said that our judges are just giving bail willy-nilly like that, as if we are operating kangaroo courts in Jamaica, because that is not so.
Yes. But I do have a challenge with a section in the Bail Act. You mentioned it earlier. And I'm wondering if we don't end up discriminating against a particular group of people as a result. So, for example, the legislation says in deciding whether or not any other circumstances specified, is sufficient to grant or deny bail. The deciding official here, being the judge, would consider, for example, the prevalence of offenses of that type in the community or in Jamaica. I just felt that was overly broad. So if I come from a particular community, just because I'm charged with an offense and I'm from that community, it seemed like it could lead to...
Not even charged, could also be suspected.
Well, this is the post-charge we're referring to now.
Sure.
Yeah. So, I don't know. What do you think? Are we off with that view?
Well, even with post-charge, your presumption of innocence should stand firm until you have pleaded guilty or found guilty. And, there are some communities, yes, the crime rate is a little higher. But it can cause a lot of problems because there are persons, upstanding citizens who live in these depressed communities that I would call them then, who can easily be picked up by the police tomorrow and they're charged with a crime because it is said that John Brown looked like Sam and he's simply charged and placed on an ID parade. And then because a particular witness knows John Brown for a very long time, they use that witness and they naturally pick out the person who they know. There's so many issues that can come as a result of that. So it is discriminatory in my view.
Okay. Jade? Oh, we're upon the break.
Yes.
Mr. Hyatt, just a few more minutes. I want us to touch on post-conviction. And given that you've already been convicted by the courts, what right could you possibly expect at that stage?
Yes.
Public opinion.
Stop this foolish about this GLP and PMP business. We are a Jamaican.
Different people.
It's not a matter of a JLP or a PMP. I think it's more like where it is that you think you're comfortable, what support you can afford to make the country better.
Different views.
Most entertainers, they're not amenable to management, so the only thing that can ultimately structure them is the court and the prison.
Public opinion. The voice of the people at 6:25 p.m. weekdays during Nationwide at 5. Tune into Nationwide at 6:25 p.m. for Public Opinion, where the people's views matter.
Public Opinion is brought to you by Cleasing Industrial Supplies Limited, Industrial Automation and Control Solutions.
Welcome back to Let's Start Justice. We've been discussing the Bail Act with Matthew Hyatt, attorney at law. So we wanted you to give us now the post-conviction, because as Mikhail said, you've already been convicted of an offense. Why are we even talking about bail?
Gone.
Yeah, you're not innocent now. We're sure of it. So why are we talking about bail now?
All right. So the Act has an aspect of post-conviction bail. And it says that after the defendant having been convicted of an offense, in relation to which the defendant now, and this part is important, the defendant must have been out of custody on bail immediately prior to the conviction. And then he can apply for bail pending the determination of an appeal. And of course, the appeal would have been made against the conviction or the sentence. And so, for example, in the parish court, you can appeal and you can ask that or an application can be made for bail pending the appeal. That is a situation that applied before and still applies now in those circumstances. But you must have been out of custody on bail immediately prior to the conviction.
Okay.
I think there was something that said that if it involved, I believe, was it murder and firearm, it would not be considered? I'm speaking from memory, forgive me. Jade, you can quickly check. You're quite good with that. Okay, but in the meanwhile, thank you so much, Mr. Hyatt. Is there anything else around the Bail Act that you think the public should be aware of?
Yes, just one thing that I had mentioned earlier. There was a provision that had stated that where the offense is murder, and self-defense does not arise on the prosecution's case, then bail may not be considered. I am hoping I'm correct when I say that bail may not be considered.
Yes, it was shall before, and it was the intention was shall, and it was adjusted to may.
Right, and then another aspect is where it said that where the offense is murder and it is committed within a zone of special operations or in any area in respect of where there's a state of public emergency. Now, I know that recently, where they had the 8 persons unfortunately killed in Clarendon, a large portion of the country, if not of the parish, sorry,
Well, all of Clarendon, yes.
all of Clarendon was under a
Mm-hmm.
state of public emergency. Now, can you imagine someone who is charged for murder? And remember, now we're saying you are innocent until proven guilty or otherwise. Yes? Then no bail would be considered. I'm pretty sure the judge would have this provision in mind.
Mm-hmm. So
And
yeah.
yes, go ahead, go ahead.
Now I was saying, finish your thought, because I wanted to just jump in. I thought you were finished a second. Finish it,
Yes,
please.
no, I am saying it is unconstitutional in my view.
Mhm.
I don't believe it is a just provision in the act. It is discriminatory because I've never seen any zones of special operations happen in certain communities in Jamaica.
Mhm.
And it is just so broad. Any area in respect of which a state of public emergency is enforced.
Yeah.
It is a very broad part.
And the challenge I'm having, and if you remember, Mr. Hyatt, around that time there was the judgment, the ruling coming out of Trinidad, around bail and murder, and bail automatically being denied, being ruled unconstitutional there.
Mm-hmm.
So I think we adjusted based on that ruling coming from Trinidad by saying may. But the question is, by having it as a possible, I say, instruction to the courts, I join your concern there. I share it. Because if the judges would have been looking at these things before, why is it necessary to spell it out? I have some concerns, especially anticipating the Enhanced Security Measures Act and what that could possibly look like. When we don't have everything together, you don't know the full implications of these legislation, and that's the challenge we're having here at JFJ.
Yes, because even without spelling it out here, when a person, in my experience, goes before the court charged for murder, the judge doesn't treat it like a person who is charged for larceny.
Mm-hmm.
First thing the judge will say is, Mr. Hyde, these are serious allegations. And they start there.
Yeah.
And even in looking at, for example, if bail is to be considered, the judge is not going to put back that person in the same community that the murder is alleged to have happened.
Yes.
The judge will say, okay, we need an alternative address to send him far away because, one, we don't want it to go back into the community and possibly interfere with any of the witnesses.
Yes.
And two, for your own safety too, because the community members might say, we hear that John Brown get charged for murder and want to go and kill that person who is absolutely innocent.
Yes.
So there are many aspects and moving parts to the Bail Act that our judges have to take into consideration.
Yesterday, Mr. Hyatt, and let me speak from JFJ's perspective before I ask you to respond. We've heard the parliamentary opposition indicating that their own version of dealing with pre-charge detention is that they will be limiting it to 300 known violence producers. And whereas this Bail Act has the involvement of the police and the justice of the peace in offences that carry too significant of sentences, the parliamentary opposition, the People's National Party, has indicated that their own version of similar provisions would include the judges. Now, from JFJ's standpoint, we think that is also very problematic because it goes back to the point to be depriving people of their civil liberties for an extended period of time without sufficient evidence to prefer charges.
Yes.
It is still
Yes.
wrong. I'm not sure if you've heard the People's National Party speaking on this and what your opinion of it may be.
I must confess I didn't hear that, but what I will say is that our police officers cannot detain persons and then do their investigations. In the US, the police officers are very thorough and they make sure to pin you down. They have all the evidence and then they charge. You're almost sure that they have the right person at times. Not all the time, but most times. And to have persons detained on a pre-charge and then do investigations, we don't know how long that is going to take. And so it is as if you're having the sword of Damocles hanging over
Yes.
that person's head for an indefinite time. And as the listeners heard before, up to 12 months. And then after that, there are no charges after 12 months. Then what? What
Yes.
happens to that person who has to report to the police station once or twice per week? It is unconscionable.
And we can learn from SOE where people lost their jobs, lost their houses as a result. One person was basically left homeless. His pregnant girlfriend as well had to sell car and so on. So the experiences of the state of public emergency is certainly there that we can learn from.
Oh, yes.
Yeah. But Mr. Hyatt,
Oh, yes.
Jade?
Well, thank you, Mr. Hyatt. We appreciate your time. I'm sure we could keep talking about this. And maybe we'll have another show on this topic just to get into some more of these provisions. But thank you so much for your time.
Well, what I will say, when you are ready to talk about the mandatory sentencing
Yes.
for firearms, then I am totally against that. 15 years, totally against that.
Well, say less. We'll reach out. Thank you again.
All right, appreciate you.
Thank you for having me.
All right, have a good day. Bye-bye.
So I just wanted to clarify some things before we have 4 minutes. So I just wanted to clarify some things we saw in the chat. Firstly, I saw a question asking if we can record the police. Yes, there is nothing in our legislative provisions that prevents us from recording a police officer who is executing their duty. But of course, there are provisions that prevent us from obstructing the police while they are executing their duty. So if you're going to be filming, ensure that you are not doing so in such a way that the police would not be able to continue to execute their duty as they should.
And if you're being arrested, absolutely no. You ask somebody else to record.
Exactly. I saw news commentator when Mr. Hyatt was speaking to the considerations that the court takes when considering bail, to ask if the police is not credible. I just wanted to clarify that what Mr. Hyatt was pointing out were those instances where the police give what we call hearsay evidence, which under any other normal circumstances in court, regardless of who the person is, including the police, they would not be able to give that evidence, right? What is needed is for the police to show actual evidence, so intelligence, something more than your opinion, right? Something to support
And it can't be that you just
opinion.
have reasonable suspicion and you're denying people who have not yet been charged for such an extent.
Well, actually, yes, you can, if it is reasonable suspicion in line with what the legislation and common law actually say,
Yes.
and not
I'm
reasonable
talking in
suspicion in
principle,
your
not
mind.
the law.
Right. But yes, so I just wanted to clarify that. And the final thing I wanted to say as it relates to the post-conviction bail is that it cannot be considered for all of the offences under Part 2 of the first schedule. So that
memory not so bad
includes so that includes the murder, as you said, but it would also include gang offences, firearms,
And that is
so on.
problematic because I remember there was a case where the father mistakenly shot and killed his child. I think it was in Portmore.
Oh, yes,
and he
yes,
was
yes.
appealing. And I think to automatically deny that person bail based on the circumstances, it's sad. And that is why everything, in our humble opinion, must be treated on a case-by-case basis. That's the point when I remember that particular case.
All right. So...
George is asking very quickly if we stated our position on the detention of known violence producers. Yes, I did. I stated what the parliamentary opposition is proposing is also quite problematic, and it's simply a more palatable version of the government's current position. And I think if it is that you're going to be utilizing any semblance of pre-charge detention, it cannot be for the extended period of time that either the parliamentary opposition or the government is proposing. The more palatable version that we had proposed during the Bail Act parliamentary submission was a period not exceeding 14 days. And even then, for us to even put that forward, we had to wrangle with the board a little bit. Yeah.
Indeed.
But we're out of time.
Yes. So I just want to say, news commentator, you've won our trivia.
Again.
We will reach out to you. But the answer to that was Minister of Legal and Constitutional Affairs, Marlene Malahou Fort, who would have chaired the committee that reviewed the Bail Act.
Yeah.
So, this was Let's Talk Justice. I'm Jade Williams.
And I'm Mikkel Jackson. Have yourself a very good week.
Jamaicans, by justice, the people's champion. Justice for all. Justice under the law. Justice, Jamaica demand. Right to life, right to liberty. Out of many we are one in a Jamaica. Make it a better place for the boys and girls. Created equal by the creator. For equal rights and opportunities. No to unlawful detention and police brutalization. Class, gender, race or religion. We not tolerate discrimination.
To join the fight against injustice, contact us at 755-4524 or JamaicансForJustice.org.
The people's champion.
JP said name is banana chips. 20% more chips in the banana left on ground. The time by JP said Mary's banana chips is
2:01.
The usual story is told. Mothers wash the clothes. The bloody